Пане Олеже, вітаємо вас на
Hello,
другому етапі
welcome
конкурсного
at stage
відбору
2
до
of the
Вищої
selection for
кваліфікаційної комісії
HQCJ.
суддів на етап
The
співбесіди.
interview stage, your interview will be conducted by the full composition of our commission.
Коротко представлю її
So let me
членів. Це
introduce our
Стівен
commissioners.
Маркман, я,
This
Іван
is
Міщенко,
Steven
Сергій
Markman, me,
Верланов,
Ivan Mishchenko, Sergey
Євген
Verlanov,
Мєзенцев,
Yevhen Mezentsev, Tadza Zhechny, and Robert Brugheisen. The rapporteurs for your interview are Sergey Verlanov and Steven Markman.
Якщо з якихось причин співбесіда буде
Should for any technical reasons your interview be interrupted, we will get in touch with you and reschedule it for a different time and different day. During the interview, well, the essence of the interview is about a Q&A session. You will be asked questions by our commissioners, and we are asking you to be precise in your answers. And a commissioner asking you a question has the right to limit the time for the answer. Before we start with the questions, you will be given an opportunity to tell us a little bit more about your motivation, about the ideas that you have, why you have decided to participate in this selection, what is your view of the activities of HQCJ, but it's up for you to decide. With that, I'm passing the floor to my colleague, Sergey. Steven, you're welcome.
So, following our agenda, let me tell briefly about you according to your CV. So, Oleh Tsybulia, born on December 11th, 1982, higher legal education, higher economic education. He started his labor activity in August 2001 as the secretary of the court hearing of Moskovsky and now Holosevsky District Court, and he worked as assistant judge in that very Holosevsky District Court of Kyiv. Then he worked in the State Securities and Stock Exchange Commission, and starting with March 2010 up to March 2012, he worked in different positions within the National Bank of Ukraine. And starting with March 2012 up to February 2014, he worked in the National Commission on Securities and Stock Market. Then he worked in the territorial department of the National Commission as deputy director of the department of this commission. Then from August 2014 up to June 2015, he worked in the public joint stock company Brock Business Bank as the deputy director of the law department, and then he worked in the deposit security fund up till May 2016, and since May 2016 up till present, he has been working within the National Anti-Corruption Bureau of Ukraine, and he has the position of head of the department of working with special assets of the law department and supporting representation in courts. He has got work record 18 years, 5 months in the field of law. And well, that seems to be it. So, Oleh, now, according to our regulations, the Commission will give you an opportunity to speak for about 5 minutes in order to explain your motivation for participation in the competition. You're welcome. Thank you, dear Commissioners, for the opportunity provided to me to speak to you in order to show that I meet the requirements for professional competence, have the knowledge of the functioning of the judiciary, have got analytical skills, capacity to work persistently, and to interact with others.
Пані Олеже, прошу вибачення.
We are sorry, but the point is that there was no connection and we didn't hear what you said for about a minute. So maybe you should start from the beginning. Start your introductory speech and start talking about your motivation from the very beginning. Well, thank you. Let me try to do this once again. I will, in a way, continue. Okay, but from the beginning for us to really hear your motivation, it's important. Can you hear me well enough now? Yes, but for a period of time we didn't see you. And can you see and hear us? Yes. All right, so please start. So decisions of court are the product of intellectual activity, and the judge has the responsibility over life and deaths of people. And as a result of my professional activity, I sometimes witnessed some mistakes, even purposeful mistakes of judges when citizens didn't get the fair decisions. But knowledge of procedures has made me sure that I did everything I could to actually reach justice. But not everybody has legal education, and not everyone can really pay for the lawyers' services. Again, we have a technical problem.
Зараз. Ярославе.
Ярослав?
All right.
Да, доброго дня ще раз, пане Олеже.
Good afternoon once again. Good afternoon, Oleg. Sorry for those technical inconveniences. Can you hear and see us now? Yes, and I hope that you can also hear and see me. Yes.
Тоді
So,
вам пропонуємо продовжити
we suggest that you
нашу
continue
співбесіду щодо пояснення вашої
explaining your motivation. Thank you. I think that decisions of courts are the product of intellectual property, and the judge has the duty to pass the final decision on the issues of life, freedom, and rights of citizens. And if your case is the case considered by a professional judge and a man of integrity, he will pass a good decision. I witnessed mistakes, even purposeful mistakes, in the judicial activity, which led to the fact that there were no fair decisions. But knowledge of fair procedures has enabled me to make sure that I will do my best to achieve justice. But not everyone in the country has legal background and time and money to pay for the lawyer's service. And to generally to pay the services to appeal the court decision. That's why I'm willing to join in the process of selecting judges who have moral internal safeguards against injustice and who will pass clear and reasoned decisions. I have a lot of experience of working in courts, representing my employees in the courts of all instances. I've got experience of working with information on the financial status of people, experience of processing processing information in a joint body, working with a joint body, and the experience of organizing the work of the team and advocating my own standpoint. Let me focus on the following directions I could work in the HQCJ. I could support activity of cooperating with the Parliament, with Secretariat of the Cabinet of Ministers, ministries. I could work with laws, provide legal support of staff provision, as well as cooperation in information exchange. And for several years, I have been on a selection commission of the National Bureau, which follows the principles of your commission and of the HQCJ. Also, we have several stages. We test knowledge of the law, general erudition, general skills, psychological tests, MMPI, polygraph testing if necessary, and polygraphic one. We also have interviews with candidates. In the current situation, the procedures of the HQCJ should be quick and efficient and very cautious about the decisions that will be passed, and the decisions should correspond to the law and to common sense and pose no risk of cancelling. That's what we should offer the country that will win in the war and will get a peaceful life as a partner of the EU and member of the EU, and that's what we are going to pass to the next generations. Thank you. Thank you for your explanations on your motivation for participation in the selection process. And now let's go over to the Q&A session. And first of all, let me voice the questions that the civil society organizations have provided in the letters sent to the Commission. In May 2022, your wife, Nikonets Irina, crossed the state border with her children driving Mercedes-Benz Sprinter of 2015 year of make. The data on the car is not indicated in your declaration. That's why civil society organizations ask you to explain what kind of car it was and what were the grounds for your car using it. Thank you, Your Honor. My wife was driving this car, and you can see it from the name that this is a van, a microbus, and she was using it as a passenger. This was just a route or taxi, I don't know what we call it, and it took her for several weeks beyond the territory of Ukraine for certain recreation procedures, and she came back by the same car, as far as I know. This was a microbus. She was a passenger. She was not driving, or she was not the owner. So she was just a passenger together with the children, yes. Here is the next question asked by civil society organizations. According to NABU certificate, since 2020, you have been owning Toyota Land Cruiser Prado, and the cost is more than 1.6 million hryvnias. Could you please explain the sources of income for the acquisition of the car? I provided the explanations, and let me voice them orally. This amount is wrong. The cost, the value of the car of the date of acquisition was 1 million hryvnias. I provided the purchase and sale agreement price lists. About the sources of income are the credit money. The credit I took, and I will still have to pay this credit for 5 years, and only after that I will become a full-fledged owner of the car. The source of income for the first installment and registration of the car was my salary, also sales of my previous car, and some savings from my previous salary. It was necessary to pay 100,000 hryvnias as the first installment and 100,000 for registration and insurance. And I'm paying this credit. I have provided a copy of the credit agreement. Clear, yes, we really have this document, these documents on the acquisition and of the car and on the credit. Here is the next question. You own 2 land plots, 441 square meters and 159 square meters, located in the village of Cherbanivka of Obuchiv, this Ryan. You bought them on the 27th of February 2019, and the cost of those land plots, as indicated, is 34,600 hryvnias and 13,100 hryvnias, and you bought it at the auction. So what kind of auction it was, and why is the price so low, since the average price of land plots in this inhabited settlement is higher? These land plots are located, well, there are 2 of them, because they are located on the border between the village and the periphery of the village. That is an experiment of mine, in fact. I just wanted to know what land plots are like that. That lot was somehow not bought by anyone, and that's why the price was going lower and lower. There is no electricity, no light, no sewage there. It's not attractive. It's located in a very distant area, remote area. We used to have kind of garden cooperatives, and the land plot was privatized, but the owner of the land plot had some problems with payments, and the executive services took the land plot away from him, trying to sell the land plots, and I just was interested in how these auctions work, and as a certain type of investment, I bought these land plots. This is actually 1 land plot, which consists of 2 land plots. And what was the procedure at the auction? It was the auction based on enforcement of the court decision. It was not the private performer, but it was done by the state service. So it doesn't matter. I just mean that there should have been some decision, as you have claimed, and you won in this bidding, in this auction. And this is the amount which was actually stated in the lot. Yes. It was the third or the fourth time when the price was lowered because nobody wanted to buy this land plot. Thank you. It's clear. The next question. In your explanations on the motivation and your motivation letter, you have indicated that you're a member of the selection commission of NABU and that you're involved in processing of the requests and packages of documents coming from candidates. You participate in the interviews. Please explain to the commission what experience would you take that you already have got from the work within this commission to be applied during selection and assessment of judicial candidates and incumbent judges. You're welcome. Well, first of all, I would recommend all those who will then become members of the HQCJ, be it me or not me, to get information from as many channels as possible and to verify this information on the basis of documents. Now, if we compare the situation with the previous situation over the previous years, now the interest of the society is rising, and we need to check movement of citizens to other countries. In particular, over the previous years, there are movements to Belarus and Russia and availability of foreign citizenship. I would first of all recommend to do the following. What I do is when I try to look at the documents, I check whether all the documents have been provided to me, and if I have no doubts about those documents, during the personal interview, I try to correlate the documents with the candidate. If the candidate declares low level or declares low level of income and property, but he has got a very expensive watch on his wrist, that casts some doubt on what the source of income for this watch is and why he has not declared this. This is just an example. If I can see some tattoos, and they are somewhat symbolic. I mean, these are not artistic tattoos, but they have some civic standpoint expressed in them, then we need to ask questions about previous convictions and check whether there have been no previous convictions. So that shows that we have to work with the candidate himself or herself and to see whether he corresponds to the image which you get while processing his or her documents, because our brain sometimes build the wrong picture. Again, let me repeat that as many channels should be used as possible. Okay, and let me ask a follow-up question. Suppose you identify a tattoo which is suspicious, as you think, which is not just of artistic value. What would be your further assessment of this tattoo? What would you do? Well, this is not the grounds for discrimination of the candidate, of course. I've just given it as an example because you mentioned something like this in one of the previous interviews. What I mean is that some doubts arise, and you just need to check whether doubts are right or wrong. But don't you think that this is the violation of judicial ethics? No. Good, thank you. Thank you for your answer. I could even tell you that I have seen prosecutors and judges with tattoos from the past in the army or from some of their previous experience before they became judges, just from young years. But then they changed their attitude to jurisprudence, to law, and they became good professional lawyers. Good, it's clear. Let me now give the floor to my co-rapporteur, Judge Markman. Stephen, you're welcome.
Thank you. Thank you, Judge, and thank you, Mr. Tsybulia, for participating in our competition. We appreciate that. Let me ask you what I consider to be a threshold question here. As you know, individuals on the High Qualification Commission must have 15 years of professional experience in the field of law. I understand the field of law to communicate the idea that you have to be doing something more than an incidental practice in law, but you have to be doing something that probably requires legal expertise and a legal degree. I don't know if you agree with that or not, but that's the way I understand Article 94 of the law to read: professional experience in the field of law. And to me, the field communicates something in addition to simply having an occasional matter of law before you. Can you give me an illustration of what, for example, you did when you were with the State Commission on Securities and Stock Market that you think might have fairly contributed to your professional experience in the field of law? I'm not calling into question at all your expertise or any other aspect of your background, but simply whether or not you've been engaged in the particular kind of law that seems to be required under our law.
Thank you for the question, Your Honor, and thank you for the opportunity to recall my past, something from my past. In the National Securities Commission, as you can see from my work record, I worked in the law department, and I had to deal with the work of the judicial lawyer, court lawyer, and representation in courts, preparation of decisions, including decisions of the joint body for it to be passed if necessary. And I also dealt with preparation of the standpoint of the body in case the decision was going to be appealed in courts. Later, I had some top positions, managerial positions, and they were related to legal actions like issuing licenses or approval of the significant participation of the owner. Or legalization and verification of the financial and legal status of the owner for him to be given this right to have this significant participation. And again, I had to prepare the decisions of the joint body, and I had to check whether the package of documents corresponded to the law.
Was it a
It seems to me that this is all activity in the field of law.
Was it a requirement that all individuals who did things similar to what you've just described had to have degrees in the law? Were there people there who did those same things who did not possess the degrees?
Well, there was a requirement to have legal background. If you hold a managerial position, one of the requirements is legal education, higher legal education for such positions. When I worked in the law department and when I represented the body in courts, it was also necessary for me to have higher legal education. That was the requirement to the candidate to have such education, and the functions of the person were to represent the body in the court hearing. So it was necessary. The requirement was to have higher legal education.
Would much the same have also been true of your experiences with the the Deposit Guarantee Fund and the National Securities and Stock Market Commission?
Well, yes, Your Honor. I would say that this Deposit Guarantee Fund and my work in the bank were also related to the fact that this was a very difficult time in the life of the country. The bank collapsed, and tens of banks were forced to be liquidated because owners of banks were fleeing together with the money, if we put it simply. So they were looking for people of integrity who'd be working in banks after they were already under liquidation or under temporary administration, because there was a need to prepare materials for law enforcement bodies, and it was necessary to take active and proactive actions in courts to still leave the liquid assets in the banks. And we had to promote this positive practice of court hearings in court decisions related to appealing of the decisions of the liquidator of the bank and the Deposit Guarantee Fund and the National Bank of Ukraine on the legitimacy of bank liquidation or on decisions when the rights of the bank owner were stopped. So this means court activity and working with documents.
Okay, that's very clarifying. I appreciate that. You also spoke about some of the work that you did with NABU, and you spoke about valuation of things like watches and document analysis, and I'm sure that was just the tip of the iceberg of what you did there. But let me ask you a question that's relevant to that. Given that the High Qualifications Commission will presumably have full access to the resources of NABU and full access to the expertise that NABU brings in so many areas, What will be the advantage of putting somebody like you, however qualified you are, and doubtlessly that's very highly qualified, what will be the advantages of actually placing you within the High Qualifications Commission instead of maintaining the traditional access that the Commission would have to NABU?
Thank you for the question, Your Honor. But I will try to rephrase the question and explain to you why I want to rephrase it. The point is that there are a lot of databases, the administrators of which are different executive authorities, be it border crossing or some tax information or ownership registries or car registries. These are all different ministries who are responsible for these databases. And some bodies of executive authorities can actually connect to all those databases and be using them. NABU uses them to prevent corruption. And the HQCJ has the same right to connect to the database to create the analytical unit in order to use the information from all those registries and databases, which means that neither NABU nor the HQCJ are creating information. They just have access to the information and know how to work with it. And suppose you mean some certificates. The certificates, the documents that you will see will just show you that the specialist takes the information but does not create, this information not created. That's why actually NABU is different, because currently the HQCJ and the Selection Commission cannot be effectively using the rights that they have, though the rights are equal to NABU. I don't know whether I've been clear in my explanations. I will try to simplify my answer for it to be clear.
Okay, thank you. Thank you, Mr. Tsybulia. One more question. You indicated that you were encouraged to participate in this competition on the basis of what you heard, that this commission would provide candidates with an open, honest, fair, and unbiased competition. Have you been disappointed in any regard so far?
No, I have not been disappointed, and regardless of the decision that is passed, I will not be disappointed. Because judging by the interviews I have watched, and judging by the questions that are being asked, I can really see that you truly want to choose the best. And I want to wish you good luck in this, and to guarantee that I will not doubt your decision.
But are there ways we might have strengthened the competition?
It seems to me that the prospects of your work and the prospects of the HQCJ presuppose that when the documents have been submitted, when the selection has already been launched, and when we have active actions, I mean, the interviews are already going on, and you're approaching the decision-making stage on the candidates, you cannot be changing the rules of the game. And because this may lead to some doubts concerning the decisions you have passed, and that will be the ground for appealing the decision in court, and will even lead to the negative decision of the European Court of Human Rights, because they claim that you should not better change the rules of the game during the process. But as far as my recommendations are concerned, well, let me use some even funny examples about tattoos of a person which I showed you. I just tried to explain that it's necessary to compare the documents you get with the information you see from candidates live, and which the Civil Society organization provides you with. Because even in this selection process, it was a surprise for me when, on the one hand, I read some journalistic investigations related to some activity of one of the candidates when he probably was not yet the candidate for this selection. and this is related to the influence on the intervention into the independence of judges, when chief judges 3 or 4 times, in spite of the law, because of knowledge of some life hacks and procedures, are re-elected. They are re-elected for 3 or 4 terms, and you're told that it's okay, it's legal in this society to do this. So as far as such situations are concerned, I would advise you to be more scrupulous. That's the only thing. Thank you.
Okay, thank you very much. Let me turn you over to my colleague, Mr. Burkhuizen, please. Thank you.
Thank you, Stephen, Mr. Tsybulia. When reading your autobiography and your motivation letter, what struck me is first your motivation. I would expect that someone from NABO would write something about his motivation, about corruption and avoidance of that. But that's not what I see in your motivation letter. You write in your motivation letter that you believe that the judiciary should have high moral qualities, knowledge and professionalism, and that you hope that your knowledge can contribute to that. But that's, of course, what all the candidates say. And when I read your motivation, it's not clear why we would be selecting you. What would be the motivation to participate? Is it only, let's say, getting a better job? Or is it do something for society? Or is it the future of Ukraine? Or area of interest? Please explain.
Well, thank you. It's quite a comprehensive question, I would say, and let me try and split it into small fragments. I have not mentioned corruption in my motivation letter because I'm a perfectionist, and I do believe that the judiciary is becoming better step by step. And I set the objective which I want to reach and not the starting point with which we start our communication. Right, there are some manifestations of corrupt conduct, corrupt actions, and the National Anti-Corruption Bureau is effectively fighting these manifestations. The society is counteracting it as well. The economic situation and the war in the country have made this sense of justice in the society more acute, more relevant. That's why in the motivation letter, I just didn't want to speak about the starting point where we start everything. I wanted to focus what place of destination we're going to reach. Why me and not somebody else? Well, while getting acquainted with the requirements for the candidates, with the eligibility criteria, and with the requirements set for the functional duties of a member of the HQCJ, I realized that the experience I have will be sufficient to make the work of this body better. I was trying to establish cooperation with the previous composition of the HQCJ, and I know the selection processes of 2012 and even before. I'm acquainted with these procedures, and I've got some experience of communicating with the judge elected through the voting procedure, but by the district residents. That is some of the past experiences in Ukraine, the way we used to have it. Why I have decided to apply? Because my experience and my knowledge are sufficient to quickly get into the matter, to understand what the HQCJ lacks and how we can launch this mechanism for it to start functioning effectively. I don't have to make some basic analysis on what has been done and what should be done, because I'm more or less already in the topic. I know what needs to be done right now. And the authorities and the European Union are setting a very clear task for the HQCJ and a very clear timeline. And for some reason, I didn't hear about this from other candidates, because there is a duty to do something within 30 days.
Thank you. Well, your answer is a bit what I expected, because if I look at your answer to the question to explain that you comply with the criteria of professional competence, you first refer to your experience when you were an assistant judge, which is, I believe, 70 years ago when that ended. It's a long time ago. And then you refer to your experience within NABU of selecting people and reading packages of documents. And that means that you apparently rely on your personal experience with selecting and not at all on your experience as or knowledge of corruption. And then, of course, the question arises that we have quite some candidates who have knowledge of the subjects you say that they have. And why would, because first I thought the NABU guy, that would be someone who has real knowledge about corruption and is a corruption fighter, but I see you much more as someone who is, let's say, data-driven person who says that you have knowledge of the judiciary of 50 years ago and some knowledge of analyzing documents and selecting. So how can you comment on what I just said?
Well, I really started working in the judiciary rather long ago, but it doesn't mean that I have not been dealing with it since then. I keep working in courts because I go there as a representative of the body. That's why I do have the understanding of the current work, current operation of the judicial environment. As far as the selection is concerned, recently some calculations have been made, and the National Anti-Corruption Bureau of Ukraine had to do the vetting of more than 30,000 candidates to just hire its own staff. As far as our cooperation with the HQCJ is concerned, I really prepared information materials like the ones you have in relation to me. But it was not clear why the members of the HQCJ ignored those materials. And the persons who were suspicious, according to our information, in terms of the sources of income of their property and assets and their way of living and the correlation between them, and these people got positive decisions from the HQCJ. So my motivation also is to use all those developments that NABU has and the ability to work with information, to process information. These are the things that should be an inherent characteristics of the body, which needs these characteristics to complete some procedures and not to generate problems in the judiciary.
Okay, thank you. Let me pass the floor to Mr. Zazetsi.
Mr. Tsybulia, in your opening comments to the Commission, in your motivation letter, you make this point: the previous members of the HQCJ, the terms of their election, and the reputational background personally caused me to doubt the decisions they made. Now, I would be interested in understanding from you what doubts you had about the decisions they made. And let me put this in a context. Prior to its dissolution and discontinuance, the High Qualification Commission of Judges worked very hard to fill the many positions in the new Supreme Court of Ukraine, and as well the 38 or 39 positions in the High Anti-Corruption Court. Those two courts, as we have been hearing from some other candidates, appear to be well respected and appear to have a higher level of confidence than perhaps exists with other courts that were appointed longer ago. So to take a balanced view, you seem to leave the impression that that the HQCJ members were terminated because their decisions, there was great doubt about all of their decisions, their recent decisions. How do you reconcile those two perspectives?
Well, thank you for the question. It's rather easy to actually combine these two principles, both the previous composition and the previous compositions and the last composition of the HQCJ were liquidated following the same principle. The law was passed and the law was passed because of the doubts in the legitimacy of their actions. As far as the selection for the Supreme Court and the appellate chamber of the High Anti-Corruption Court are concerned, these selections were supervised not just by the HQCJ but by international experts and the public, and I think that this was a safeguard. And it was a result of that safeguard that these decisions were passed and courts started functioning, and lawyers really admire those courts because of this scrupulous attention to the selection processes. The previous composition of the HQCJ at the same time started, it did not complete 7 more assessments and selection procedures that they were trying to implement, but since they ignored detailed information and decisions of or information coming from the public, they somehow failed. They passed unconventional decisions as compared to the previous compositions of their predecessors. They evoked a wave of indignation, and they were actually the hostages of their own idea that they should create 2 or 3 courts, create a positive impression, and then they wanted to use it for their own benefit. But that was quite an arrogant decision, an obvious decision. That's why the parliament passed even the whole law to liquidate this commission once again, to terminate the mandate. So I think that the personal internal safeguards of those people did not work.
All right, and you actually bring forward a reference that I think is an area that I would like to ask some questions about, and that is the role and involvement of the Public Integrity Council in the work of the HQCJ. You speak very little about that in your motivation letter, and I'd be interested in hearing your opinion as to what role can be played by the PIC and whether or not their recommendations and acceptance of their recommendations should be enhanced.
Ваша честь, після того, як ви зробили зауваження по мікрофону,
After, well, you know, for some reason, I was listening to you in the English version because of the technical problems. So let me try to answer the question.
щодо того, наскільки необхідно
As far as I've got you,
громадську раду доброчесності та міжнародних
the question was about involvement of the PIC. I think that, now I heard the translation, so I think that
Питань без проблем. Я в цьому жодного не бачу,
the HQCJ should
тому що перекладу.
take into account the recommendations of the PAC. And if we take the National Anti-Corruption Bureau and its selection commission has 2 or 3 representatives of the public who have the same vote as I have. They also work with documents. They also make some statements and recommendations. We have a discussion of the candidate. And we are trying to reach a conclusion and to pass a decision on a joint basis as far as recommendation of this candidate is concerned. So due account is paid to the position of the civil society. I've got experience, quite a long-lasting experience for some 5 years of working together with the PIC. They're not doing any bad things. They're just trying to bring information to the notice. This is the information which probably is not available in the judicial dossier, or this is the piece of information that the selection commission, the HQCJ, failed to find from some other sources. Well, probably there should be some more order in terms of the procedure and the period of submission of recommendations, because there have been some complaints about that. But this is just a formal element. You can just regulate the rules of interaction, and generally I don't think that there would be something bad about giving even an advisory vote to the PAC, because it seems to me that they used to be something like a watchdog, but they could not influence the process in any way, the decision-making process, if their recommendation was not taken into account. And we have had a similar situation with NABU, because the representatives of NABU were not present during the interview with the candidate. So I think that it's absolutely possible to increase the role of the PAC in order to interact and to attain the objectives. When we work, we don't have a discussion as to whether we should involve somebody in the decision-making. We reach our decisions in consensus.
Yes. You tell us what needs to be done. I am more concerned about how that is going to be done. So you state the proposition that there should be greater involvement by the PIC in the decision-making process. That doesn't tell me what your ideas are about how this can be accomplished. What are the steps? What involvement would you favor and support the HQCJ giving to the PIC?
Thank you. I understood your question. Maybe I misunderstood the question a little bit. I thought it was more general. So if we are talking about more specific ideas, as far as I remember, the final straw was with the introduction of the amendments to the regulations, and the opinions of PIC were not considered during interviews. So the practical step would be to restore their access to the interviews. I would give them the right to vote. I would give them the right to submit documents, and I would also give the candidates the opportunity to review their documents and to either prove or disprove the facts presented there. I would listen to the representatives of civil society, and when making my decision, I would provide motivation. When preparing my decision, I would provide reasoning as to which specific facts were considered or not, because I've come across these examples in the description of the activities of HQCJ when there was a conflict of interest with the candidate and the representatives of a civil society organization that was that were present during the very interview. So that is what should be considered as well.
Let me just ask one last question to follow up in this area. You say that what you would do or favor or support is giving the PIC the right to vote. The right to vote about what and at what point in the selection of judges?
When I meant the right to vote, it's not really the right to vote. It's the right to speak, the right to be heard.
і право доступу до співбесід, право там давати.
And the right to be involved in the interview, the right to ask questions. So I would not strip them of their opportunities to perform their functions. If we are talking about the right to vote, then they must become members of HQCJ, and that will result in changes to the selection procedures, and it may result in the appeal of the final decisions. Of course, we can expand the mandate of PIC, and within the new selections, we can review the interaction between the two bodies and the mandate of PIC within the new selections.
All right, and just to be clear, it was you who used the phrase, the right to vote. It was not my suggestion. So I understand your clarification. Thank you. I'm going to pass the matter over to my colleague, Judge Mezentsev.
Thank you, Justice. Доброго дня, пане Олеже. Я продовжу наше спілкування.
Good afternoon, Oleg.
Скажімо так, ретроспективі ви відповідали вже на питання.
So, in retrospect, you've already answered that question
Досить міцної фрази, якою
about this strong phrase that you have in your motivational letter, that the previous HQCJ, with its reputational background, causes you to have reasonable doubt about the decisions made by the previous HQCJ. So if we don't consider the selection for the Supreme Court and the High Anti-Corruption Court, we also had the qualification assessment of judges completed by HQCJ. And I mean the qualification assessment of judges of the courts in Kyiv and some appellate courts. In your opinion, is this method of assessment legitimate, or are you still doubting the results of the assessment conducted in 2016 and 2017? Do you consider it necessary to conduct re-qualification assessment of those judges who have completed it already? Do we need to have a new qualification assessment? No. No, and I would not recommend to have a new qualification assessment. With regards to my negative opinion of those previous decisions, it's more about the reputation of specific members of HQCJ who made those decisions. I don't see a need to review the results of that assessment, because really in Ukraine, it often happens that a new composition of somebody tries to go back and rectify the mistakes of the previous composition without focusing on further development or movement forward. And in such a way, we actually are at a standstill and we fall into the same trap. So that's the reputation of the people who made those decisions, and those decisions were either appealed or not, but the decisions are effective. But I think that we should not go back to the qualification assessment. You see, if you make such strong claims in the motivational letter, all the commissioners would pay attention to it. But fine, thank you. Now let's discuss the topic of corruption in courts, not among judges, but among members of staff.
Не так давно дуже приємний
Just very recently, we had not a very nice example
корупції,
of such
зокрема, коли
corruption
працівник суду
when
за грошові кошти
a
розголошував
court staff
або матеріали не
court
СРД,
staff
або
member
заходи, які
disclosed
вживати.
some information about proceedings in exchange for money.
Чи не варто все ж таки в судах провести
In your
певний-
opinion,
певну ревізію
would it be feasible to have some kind of
персоналу, який там працює, і,
revision
можливо,
of
ревізію, в
court
тому числі,
staff
умов їх роботи для того,
and
щоб,
also review
ну, персонал,
the
особливо той,
conditions of
який
their
має
work
доступ
so
до
that the
безпосередніх
court
матеріалів
staff,
судових
including
справ,
those who have
судді,
access
секретарі,
to court
помічники,
materials, I mean
щоб
assistant
вони,
judges,
не
secretaries,
спокушалися
so
на
that
якісь
these
легкі
people are not
і
tempted
небезпечні преференції.
to get some easy money.
Як варто зробити, на вашу думку? Прошу.
In your opinion, what should be done about this? Thanks a lot for this question. I think that it goes in line with the previous questioning that I was working in court some 15 years ago. But do you know what the salary of an assistant judge is?
Можу сказати, що я не був при цьому присутній. І я залишаю спілкуватися з
Well, I continue keeping in touch with my former colleagues. Some of them have been appointed as judges. I know about this problem with funding. I know that an assistant judge can even get a minimum wage, which doesn't really correspond to their professional level of experience. Yes, there are some internal safeguards which prevent for the system to become corrupt entirely. And neither my experience of working in NABU or an ACP tells me that all assistant judges are like that. The court system is no different from law enforcement system or prosecutors' offices in this respect. We've had cases like that, and we will have cases like that. We can maybe increase the salary of court staff, but still a person may be susceptible to corruption. But we know that courts are fighting this sufficiently. I know this from mass media. I read about these cases in mass media. I heard about the most recent case from mass media. So my question is, how should we work with court staff? Maybe we need to increase their salary. Maybe we need to enhance or elevate their status to make them civil servants. When I was working in courts, it was already taken into account, the civil service, I mean. Right now, the level of salary of a civil servant and, let's say, a court staff member is not going to be that different. Yes, but in general, we need to increase salaries. And everybody must have a decent way of life so that they don't have to choose between buying bread or disclosing some confidential information. We are talking about personal moral qualities, but of course, we need to do everything to increase salaries so that people have a decent level of salary. Assistant judges are now working under the conditions of patronage. So according to effective legislations, these people are not subject to filing their tax returns. Do you think, is it feasible to maybe make assistant judges civil servants again so that they have to file their declarations? Thank you for the question. There are both pros and cons to this. If they are made civil servants again, it's more up to the HCJ and the parliament to decide. Maybe it will improve their financial standing, but we will have more issues about selecting these people because under current conditions, it's much easier to find some people, to find these people and to find the funding. It's much easier to do within patronage service. And as far as filing declarations is concerned, it's again about amending the legislation, the anti-corruption legislation.
Я вас зрозумів. Скажіть, будь ласка, таке.
That's clear. Thank you. I have one more question for you.
Усвідомлюєте, напевне, як людина, яка
You do realize as a person
в широкому колі
who's
різних
had
галузей
a vast experience of working in different legal professions, and now you are working at NABU,
що нерідко змушується
so you must be aware of the fact that
жертвувати власним часом.
sometimes people have to sacrifice their own time for the benefit of the state, for the benefit of the institution they are working for. So you have two children, two sons, aged 12 and 7. Could you please tell us, if you are appointed as an HQCJ member, do you realize that in the near 4 years you will have to dedicate the majority of your time to working on HQCJ? There is a huge workload lying ahead. Are you not afraid of this? I see it as a challenge.
Впевнений, що обсяг робіт буде
First of all, I'm not sure that the workload will be much higher because NABU has already checked some 30,000 candidates in most recent years. Of course, not all 30,000 were analyzed by me personally, but I did do a huge chunk of work, and that was an additional work to what I was supposed to do according to my job description. So I'm ready for the workload. I know how I can manage my time. I know how to be efficient, and I know how to work with documents.
Добре, пане Олеже. Скажіть,
Thank you,
наостанок
thank you,
хотів
Ola.
поцікавитися.
And
У
my
нас,
final
Роберт
question.
При підготовці мотиваційного
Robert
листа такий, досить підступний пункт.
Has come up with this tricky question about the ethical and moral qualities that will be most hard for you to comply with. That is our question number 3. And you mentioned that it will be most difficult for you to comply with the value of care. What does it mean?
Я теж відповів, напевно, так, щоб привернути увагу.
Maybe that was another answer which I gave just to draw your attention.
Під час добору має бути дотриманий принцип
During this selection, we must have equal attitude to all of the candidates. Sometimes there may be mistakes in some appendices. Sometimes candidates may give the wrong answer. You may give them a follow-up or clarifying question. You may give them the opportunity to rectify their mistake. Sometimes you don't give them this opportunity because everybody initially knows what the requirements are. So when I meant care, I said it's to be more principled and strict because all of the candidates must be worthy, the majority of them must be worthy and professional, but we'll have to select just a few out of all of them. And if you start caring about the candidates, then you will see them all as equally good and it will be hard for you to pick.
Вважаю, що зрозумів, пане Олеже.
Let's assume that I understood what you meant, but not entirely. With this, I'm passing the floor to our chair, Ivan.
Пане Олеже,
доброго дня.
кажете 30
Ola, good afternoon. So you mentioned some 30,000 people checked by NABU.
А
Yes,
скільки суддів серед
that's
них
the
було?
rough statistics. How many judges?
Судді подавалися
Have you checked?
працювати в НАБУ?
So did you have any judges applying for work at NABU? No. No incumbent
А
judges.
ви діючий працівник НАБУ,
And
який
you
подається
are
працювати
currently
в судову
working at
систему.
NABU and you are a candidate to work within the
Як це
judiciary.
вами сприймається?
So how do you perceive all of this?
Позитивно.
My perception is positive. Don't you see a kind of conflict here? So you're working at a law enforcement body which has the function of oversight over judges. You are investigating cases. And now you, as a representative of this law enforcement body, would like to join the judiciary. Don't you see the inconsistency? Why are not judges applying to work at NABU, but NABU people want to become a part of the judiciary? Maybe because judges have lifelong tenure and they have a higher salary, which is quite enough for them. That's why they're not applying to work at NABU. And I'm working at a legal department. I'm not investigating anything. I ensure that NABU is operating just like any other government body is. So it doesn't really matter if it's a law enforcement body or not. So I used to work at other government bodies, so I cannot say that I'm a representative of the National Bank of Ukraine or the court at which I used to work. As the head of the department working with some special assets, do you personally have a lot of experience of going to courts as an individual? No, most recently not. And plus, at work, we have those staff members who are representatives in courts. And now we have been stripped of the right to file lawsuits in some category of cases. So it's more about some financial activities. So in the past, you did go to courts, but maybe in relation to some specific cases. Yes, you do have some ranging of the cases that you deal with. Could you please tell us about your best and worst experience with the courts? You as a representative of the state in court, so could you please tell us about your best and worst experience? Thank you. So again, I'm traveling down the memory lane. My best experience is us winning in the Supreme Court. And when we were awaiting the decision, standing in front of the door of the Grand Chamber, people told us that we were unlikely to win. And it was a great professional achievement for us, something that I can remember fondly. And the negative experience is when we dealt with one commercial court, I will not be naming it. And one of the parties wanted for the judge to recuse themselves. The judge listened to both parties, and then we filed a petition on giving additional evidence, and the judge did not recuse herself. She announced the decision, and that was a shame. I understand what you are telling us about. Thank you. Could you please tell us about 3 main priorities in the work of HQCJ? 3 main priorities: speed, reason, and clearness. Speed is because we have the circumstances that we have, and the HQCJ will have the work that they need to do in connection with our accession to the EU. And there is a specific timeline that the HQCJ will have to comply with. We also have the state anti-corruption program, which requires for HQCJ to make specific steps within a specific timeline. So that is something that we will have to do rather quickly. Also, when I meant clearness, I meant that everybody understood the decisions that are made. So if a number of decisions is made by a judge or by any other person, and they are all similar, but then the next decision comes, but it's completely different, and then people lose all faith because it's not motivated. Do we have any additional questions for our candidate?
Пане Олеже, наша співбесіда
Oleh,
добігає
our
кінця.
interview is coming to an end.
Підсумуйте її, будь ласка.
Would you please summarize it for us?
Дякую велике за запитання. Вони були
Thanks a lot for asking me very interesting, profound, and harsh questions at times.
напевно
It gave me food for thought.
зміню ваше запитання і запитаю сам у себе від вашого імені, які
I will ask myself a question. What KPIs would I establish for myself should I be appointed as an HQCJ member? And that KPI for me would be the honor to invite all of you to a court in Sevastopol once the selection has been completed. That's great. Thank you.
Дякуємо вам за участь. Всього вам
That's the end of your
найкращого.
interview.
Бережіть себе
Thank
і
you
до
for
побачення.
participation. Good luck and take care. Goodbye. Goodbye.